I think the urban land component is really important. I won't spend any more of my time on the preliminaries because there is indeed very limited time to address a broad, wide-ranging and complex issue. I've asked Ruth if she'll let me know when I'm halfway through because I'm very worried about the time. So urban land reform. Urban land what? We don't have a conversation in this country about urban land reform. I think that's the storyline. I think the storyline is about urban land reform. It offers us a new lens on the urban question. It offers us a way of seeing what the gaps are and what the inequalities are in a different way. This moment, this land moment that we're having in the country with the expropriation without compensation debate, with a high-level panel report, with the debates around chiefs and land, I think is also an urban land moment. So, I've structured an input. I could have done it in any number of ways, but what I've decided to do is simply take each of the three words, urban, land, and reform, and unpack them a little bit. So if we put urban into the land conversation, what happens? We immediately confront private property. The so-called market, the property market, is all pervasive in how we think about urban land and what we read about urban land. It really is the only logic that counts when we think about urban land. And yet, this private property market coexists with something else altogether, which is so invisible that we don't have the language to name it. And I'm talking about informal property systems. I don't like the word informal. I don't think it describes them properly. It's the range of off-register and social property arrangements that exist for an enormous number of people in our country. We don't have the language, we don't have the frameworks for thinking. They are not recognized, and as a result, they are not supported, and they do not receive the benefits that the formal property system receives, and more particularly the people living in the formal property system receive. So one of the questions I think I want to pose today is, whose voices are we hearing in the media? When we're hearing stories about so-called land grabs and land occupations, whose voices are driving those stories? Where are the voices of informal settlement residents, inner city occupiers, poor and working class people, poor and working class women in particular? What kind of language are we seeing in the media? The language of land grabs, hijackers, invaders, criminals, and queue jumpers, I want to suggest, is a language that conceals this other property system from the public discourse. And I think that one of our biggest challenges is to shift that in the way that we are reporting on and talking and reading about the urban land question. Moving on to the land in the urban land reform question. What about land in an urban context? Aside from the prevalence, the dominance of the private property market, we don't have a focus on land, partly because it's an institutional problem. Land is almost concealed within the housing and planning sectors in an urban context. When we look at housing in the urban context, we can think about a significant program, the Housing Subsidy program in the country, which has delivered a large number of subsidies. Quite how many is a matter of dispute. The Department of Human Settlement, I think, latest claim is about 4 million subsidies. It doesn't mean there are 4 million houses on the ground. It doesn't mean that there are 4 million new title deeds that have been registered. It means that there are about 4 million subsidies that have been allocated since 1994. This is a significant program, but there are major problems with it. The one is that most of the projects are peripherally located. And if we're talking about urban land reform, then one of the most important things that we're talking about is about spatial restructuring. And it's not happening. And the housing program has not helped us with spatial restructuring. An urban land reform program might. Which brings me to the other 2 points about the housing program, in which the urban land question is located, and often invisibly, is the question of tenure And the housing program has been a massive titling program. Its vision is to confer ownership. It is also a program of asset creation. You might have heard of Hernando de Soto. His ideas have really seduced the housing sector in South Africa with the promise of what a housing subsidy and the house it delivers can do in terms of pulling people out of poverty. The record is different though. There's a big critique of the asset focus of our national housing program, and there's an even bigger critique of the ideas of Hernando de Soto. I can talk more to those in discussion if people would like. Land is also concealed in an urban context inside the planning sector. What's important about the planning sector is it's where decisions get made in a subsector of the planning sector called development control, which used to be called development control and is now called development facilitation. It's where all the decisions about rezonings and applications get made. The other component is about land development, which used to be called township establishment. This is how our cities get developed, through these decision-making processes. What's important about them is that only owners have standing in planning law. Non-owners and occupiers do not.
Halfway.
Thank you. There's a new law, which people might have heard of, called SPLUMA, the Spatial Planning and Land Use Management Act, which promises to turn many of these constraints around. We don't yet have enough evidence to know that it will. Finally, I want to come to the reform part of the urban land reform question, and borrowing the kind of template that we have from the rural land reform sector to think about land reform, restitution, redistribution, and tenure reform. How are we doing, and what would this mean in an urban context? There is a restitution program that covers urban restitution. Ruth spoke about that, so I'll leave that aside. When it comes to redistribution and equitable access to land, I don't think we're doing very well. And the land reform program, the idea of an urban land reform program, offers us an opportunity to rethink that. So I want to briefly provide a way of thinking about redistribution. I like to think about how land gets allocated to different uses, how it gets distributed in an urban context, and by whom or by what processes. The first one is private allocation. That's where the so-called market operates, and it's how we all think land gets allocated. The other way that land gets allocated is publicly. That's by the state through various subsidy programs. Most poor people are not accommodated by either of these systems of allocation, although the public system of allocation has attempted to redress this problem to some extent. So the third way that land gets allocated is by occupation. And I want to argue that if we think about occupation in this way, in relation to land reform, in relation to redistribution, and in relation to how land gets allocated, it opens up our thinking and gives us the ability to be much more analytic about what's going on with land occupations. By the way, the correct terminology in law is occupation, not invasion, and not land grab. The other component is that there are unlawful occupations. Unlawful is the appropriate term, not illegal. They are unlawful, but they are protected by law. There's one act that protects unlawful occupiers, and it derives from Section 26 of the Constitution. You'll be hearing about Section 25 in more detail. Section 26 is about the right to housing, and the PI Act, which is an acronym, I can never remember the long form, the Prevention of Illegal Eviction and Occupation of Land Act. Unlawful. Yes, thank you. And that act gives effect to Section 26, and it means that nobody can be evicted unlawfully. It does not mean that nobody can be evicted. It means that you have to follow a legal procedure and you have to obtain a court order. I think what we often forget in the coverage and discourse around inner city occupations and land occupations in our urban and peri-urban areas is history. I didn't begin my input with history, but I think it's worth just recalling that Section 26 and the PI Act are there to address the historical legacy of land dispossession around our history of removals and the denial of access to black people to land until 1986 in urban areas. And in 1986, it was a very limited form of land ownership through a permit system. So when we're seeing occupations happening, my suggestion is we think about them in terms of how land gets allocated, by whom and for whom, and that we also think more about history and social exclusion. The PI Act is part of a bundle of post-1994 laws that you've already heard about, and I think it's very useful to see them in a basket. IPILRA, the Interim Protection of Informal Land Rights Act that Ben addressed. ESTA, the Extension of Security of Tenure Act that applies to farm dwellers that Ruth addressed, and the Labour Tenants Act that you heard about earlier. Those are the main ones. All of them protect off-register tenures. Title dominates in our country, which brings me to the third part of the land reform program. I've disposed of restitution because Ruth dealt with it. I've addressed redistribution, and now I want to come to tenure reform. There are a range of different social tenures. Ben mentioned that we address this phenomenon of social tenure in our recent publication that exist in a range of different situations in our country. In an urban context, we see social tenures expressed in different settlement forms, informal settlements, inner city buildings, backyards in old township areas, and in new developments. The point about these tenures is that they do have legal protections. In an urban context, PI is the legal protection. The problem is that if your rights are violated, you have to claim them through a legal process. What we are missing is a system of land administration that would protect those rights that exist in law already, although they aren't private ownership registered title rights. What we need, and what the high-level panel report proposes, is a Land Records Act that would recall the range of off-register rights over and above what happens in the system of title deed registration. So regarding tenure reform, generally when we discuss tenure reform in this country in an urban context, we're not really talking about reform, and we're not really talking about tenure. Generally, what people think of is title. And while title works for some people, it doesn't work for most people. The significant number of people who live in these off-register tenure systems. Our housing program has been a significant titling program. It's attempted to confer title through housing programs in a range of different parts of the country. There's very interesting research conducted by Urban Landmark and the Finmark Trust on what's happened with those title deeds and how close to 50% of them are not yet evident in the deeds registry. This, I think, is signs of a systemic failure. And we need to start interrogating the system of title deed registration much more than we are currently. Okay, so I'm going to make 2 points in conclusion. The first one is, how does this all relate to expropriation without compensation in an urban context? I think expropriation is an instrument for an urban land redistribution program. It does not require constitutional amendment, however. We have the legal basis in the Housing Act to expropriate land. There are some cases, like the Marikana case. It goes by the name of Fisher, that's a settlement in Cape Town, where expropriation is fundamental to what's going on in court. When Mayor Mashaba in Johannesburg talks about expropriating inner city buildings, his vision of that expropriation is for the market. It is for private property developers to take ownership of those buildings. What we know is that nearly 50% of people living in Johannesburg's inner city earn below 3,200 Rand a month. What this means is that private rental cannot accommodate them. They cannot afford it. For example, if you earn 3,200 Rand a month, what you can afford on rent is 800 Rand a month. If you earn 1,500 Rand a month, what you can afford is in the region of 350 Rand a month. Not for profit rental. I'm not talking about private sector rental. I'm talking about social rental delivered by a limited number of social housing agencies in Johannesburg cannot deliver rental for less than 1,300 Rand a month. So forget about private rental if we're talking about the majority of households that live in Johannesburg's inner city currently. So Mayor Mashab is completely off the mark with his expropriation approach. However, inner city occupied buildings, we would argue, is a key opportunity for expropriation. So is the land that's occupied and has been occupied in some cases for decades by informal settlement residents. Finally, I don't know if I've got more time.
No.
I wanted to just quickly suggest what some of the storylines might be. Aside from the overall urban land reform storyline, the inner city is a storyline. It is already in the media. What I think is missing is analysis. We need much more content on context. What's going on in Doornfontein when we report about what happened in Davey Street? What's the historical legacy? What the broader context is that cities are losing in court when NGOs litigate against them. They are not winning. There are no cases in which they are winning. Why? Because this is about housing rights. It's about the provision of alternative accommodation, which is giving effect to Section 26 of our Constitution, which in turn is addressing the historical legacy of apartheid. And I think when we report on these matters, we forget that context. Secondly, how are cities developing, where and for whom? I think that's another major storyline. The informalization of cities, their informal development, is critical to our understanding of where we're going in cities, in inner cities, in informal settlements. What we hear in the media is much more about criminalization and pathologizing, and much less about the distribution and allocation processes that are underway by means of occupation. Data. We need much more interrogation of the data. We don't trust the data provided by the Department of Human Settlements. Even if the 4 million figure, I think it's even 4.5 million, is correct, we need to disaggregate what it's reporting on. Subsidies, houses, title deeds registered.